can start our proceedings. I just wanted to know if you can hear me now.
Yes.
Great. As I was saying earlier, I'm Dr. Rohit Roy. I'll be the moderator for this evening. But in case my net is insufficient, then I already have standing by. She'll take over. Rohit Roy, and I'll just start our proceedings now. Good evening, everyone. Welcome to the very first big event of this truncated and effected in your association with guest lectures by renowned speakers. And today, as you all know, we are hosting one such eminent personality in the field of law, Justice Francesca Fiecconi of the Italian Supreme Court. To welcome Justice Francesca Fiecconi, may I invite our Dean, Dr. Jayadevan Nair, to give the welcome address. Justice Francesca, I believe you have interacted with our Dean earlier. So Dr. Nair, if I may ask you to come forward and give ma'am the welcome address.
Thank you, Professor Rohit Roy. I hope I am audible to all of you.
Yes, you are, sir.
Thank you. So let me first of all extend a very warm welcome to all of you who have logged into this very important special session by Justice Francesca Fiecconi, Judge of the Supreme Court of Italy. I will extend a very warm welcome to respected Vice Chancellor Father V.M. Abraham, respected Pro Vice Chancellor Father Joe Cici, Registrar Anil Joseph Pinto, Director School of Law Father Benny Thomas, and to the most important constituent of today's meeting, to Justice Francesca Fiecconi of the Supreme Court of Italy. On behalf of the School of Law, Christ deemed to be University, Madam, I extend a very warm welcome to you to this particular function. Thank you for having consented to engage our audience, our students, and our faculty in this very important lecture. It is being organized under the aegis of the distinguished guest speaker program of the International Association of Law Schools. A short profile of our guest speaker would be appropriate at this particular point. Francesca Fiecconi, Judge, Supreme Court of Italy, graduated in 1984 from Pavia University, Faculty of Law. In 1986, through a public national examination, she has been appointed lifetime judge of the Italian judiciary. In 2017, she has been promoted as a judge of the Italian Supreme Court, Rome, attached to the third civil and commercial chamber where she works at present. She is also avidly passionate about academics and is a professor under contract at the Department of Jurisprudence in the University of Milan, where she takes commercial and European law. To put today's talk in perspective, it should be borne in mind that there is a republican constitution in Italy, so there are similarities with our own constitutional structure. The document contains assurances of fundamental rights and other provisions. Article 134, which provides for the Supreme Court endeavor to look into questions of powers of the state organs and the constitutionality of laws. The Supreme Court of Italy also looks into conflicts between the state and regions and charges brought against the president. In this context, let me point out the relevance of today's theme, which is civil procedure during COVID-19 pandemic and constitutional principles. As all of you must be aware, in India too, we have witnessed questions being raised on the application of rules, regulations, and principles owing to the far-reaching impact of COVID-19 on the economy, on society, and on legal expectations. So now it's over to Justice Francesca Fiecconi to elaborate on her insights into the theme of today's lecture. Thank you. The stage is all yours, madam, for the lecture.
Thank you.
Right. Thank you, Jayadevan, sir. And today's talk, may I request the audience to keep themselves muted throughout the session. If you have any questions for our speaker, please submit the questions in the chat box. we have a Q&A at the end of the talk. And as the moderator, I will put forth as many of the questions that time permits to ma'am. Without further ado, may I now invite Justice Francesca Fiecconi to give us her deliberations on civil procedure during the COVID-19 pandemic and constitutional principles. Justice Francesca, the floor is yours.
Thank you very much. I welcome you, and I think myself virtually in your law school. I think it's a huge, wonderful law school in the south part of India, but unfortunately, so far I didn't have the chance to visit. I visited just the north side and went to Pune with the IALS, who gave me the opportunity also to know Mumbai and all your wonderful country and culture. I'm very, very excited and glad of having been invited by you. And today I just prepared a small script in order to make you available, in order to make you follow my thoughts in a fluent way, because you know everybody who speaks English speaks in a different way. There might be problems in understanding, and so I preferred to have a script guideline. First of all, I will talk about the new constitutionalism in modern times. The Constitution. What is the Constitution, first of all? In our modern times now is considered as a tool for power restraint and enforcement of the rights. And in talking about constitution, I have thought to build up and to define the pillars of the modern constitution. So talking about the first pillar, we have to say when we face with a constitutional text that the constitution has to be thought as the backbone of one legal system. You know that in the past times, normative settings and judicial rulings were left to discretionary and extemporaneous regulation, available to whom was governing a submitted community either by the obvious force of the facts or at best an illuminated vision of power. Nowadays, the constitutional norms stemming from a written constitution, what is the Italian constitution, or a constitutional tradition like the British constitution, represents a unitary set of fixed rules aimed to define firstly the structure and the functions of the state apparatus, and secondly, the state power to interfere with the life of citizens and the community in general. In such cases, it comes to the role of the rule of law and other sources of law to build a legal system complying with principles settled by the Constitution, which is the first chart to be seen. In other terms, in the construction of legal systems, the constitutional rules constitute a fixed legal entity as opposed to the flow of different sorts of legal rules. Now, let's skip to the second page, to the second pillar. The second pillar of the Constitution is the supremacy of the Constitution. A constitution chart or tradition accompanied by a flow of different sorts of legal rules and principles of laws is not sufficient to build a state governed under a constitution. There must be the recognition of the supremacy of the Constitution over the flow of legal rules and judicial statements that constitute the complexity of the legal system. That means that the Constitution, while it justifies its validity, it establishes the primacy of certain rules and values. Historically, the idea of the supremacy of the Constitution over any other sources of law has been first established by the Anglo-American legal system, namely the Declaration of Independence of July 4, 1786. Since then, equality among human beings, consent of the governed ones to the governing power, and recognition of the unalienable rights to life, liberty, and pursuit of happiness, I will stress this last one nowadays, are the basic components of one constitution also at present times. The presence of those components is essential for the establishment of the supremacy of the Constitution, as opposed to the supremacy of the existing power. So it cannot be any existing power that is over the Constitution. The Constitution is over every existing power. The third pillar is the constitutional judiciary review. The supremacy of the Constitution over other sources of law means also that law cannot contradict the constitutional text. See at Marbury's versus Madison Supreme Court of the United States Constitution, and therefore, nowadays, the supremacy of the Constitution is evidenced by the fact that a law contrary to it shall be started in effect void, and that state powers at whatever level are obliged to comply with it by not applying the contrasting law. The presence of an independent constitutional justice capable to assess whether the law complies with it or not, whose aim is not only the adjudication of unalienable rights and the definition of the state powers, but also the enforcement of those rights and the curb of illegitimate exercise of power by central or peripheral organism of the state. The judicial review of law and norms under constitutional terms, therefore, is the condition for not betraying the role of the Constitution as a tool for power's restraint and enforcement of rights, no matter how it is organized in the legal system. Indeed, even if the way to obtain judicial review of laws may change from state to state, it must serve the same purpose. It requires also reliable and independent judicial system in the whole too. The fourth pillar is the Constitution as an intangible good. Besides the presence of a public and independent authority that works as impartial guardian and mouth of the Constitution, like the judiciary, the Constitutional Court, separation of powers must be the normal way to contain excessive power and the desire to overcome the constitutional text. Separation of powers means also that the constitutional text is not a book of dreams to be realized for the advantage of the few ones to whom it is given, but a living text by which every form of power now and in the future, and every form of power and social organization shall be inspired. Mainly, the Constitution cannot work as a program of the government, since it can live absurdly in the absence of a government. Let's think about that during this time. That means that the constitutional text works as a general binding law that cannot be changed, although it may be revised by amendments passed through rigid protocols and procedures among the different branches of the Parliament. For instance, Article 139 of the Italian Constitution prohibits the revision of the Republican form. It allows revision by amendments of certain norms, but not the constitutional form, and especially the democratic form. In other terms, as the constitutional text shall not be betrayed by the existing powers, even if not formally overturned, it cannot be reduced as a sleeping beauty or a dead shell, because it is the identity element of the people organized under its basic rules. And then I will pass to talk to the last fifth pillar, which is the characteristic of a new constitutionalism, the international constitutionalism. After the end of the World War II, the states strengthened the basic principles of the Constitution by asserting the fundamental human rights in different international binding agreements, such as the Universal Declaration of Human Rights of 1948 and the European Convention on Human Rights of 1950. Even the European treaties have taken this new commitment by incorporating the same principles in the Nice Declaration of 2000, finally incorporated in the European treaties in 2009, but represents the higher form of the new European constitutionalism. Nowadays, it is the common may we shift to the next page, please? Okay. Nowadays, it is the common European legal and judicial space more than the single European market. When we talk about European legal system, we think most of all to the European market. But nowadays, this system, legal system, is thought as a legal and judicial space under constitutional principles. So that means that it's building up a legal area based on mutual recognition of states, simply harmonizing national legal systems under the same constitutional principles. The role of its two courts of Luxembourg and Strasbourg, and the widespread judicial national review proved as being fundamental in guaranteeing a common feeling of legal security and enforcement of human rights among European member states. Confidence in the European judicial area is not limited to partial responses to specific emergency, but to statements of principles of law as enshrined by the charters of fundamental rights. So over the national constitutions, there are these charters that work as the main law, the backbone of the new constitutionalism. So now we see which kind of lesson we have learned and which kind of challenges we are facing as a judiciary during and after the COVID-19 pandemic. Civil procedure during pandemic times have been really severely affected. And so the best approach to analyze the justice system during COVID-19 pandemic is to inquire on how the new international constitutional principles shall work during that time. The COVID-19 pandemic is a health crisis with serious human and social consequences. Let's think to physical distancing, social lockdown, stress on healthcare compartment, hard restrictions of personal and enterprise freedom, etc. All factors that lead to government supremacy over legislative power. As a positive effect, It has also created challenges, in my opinion, even for courts and judicial authorities in the member states. As regards to the justice system, it invites to reflect on the innovative measures that can arise within judicial systems. During these times, the European Commission for the Efficiency of Justice, the CEPEJ, is named after a French way to call it, CEPEJ, of the Council of Europe, supported the member states in improving the efficiency and quality, both efficiency and quality of their judicial systems in order to ensure that they operate in line with the standards of the Council of Europe and meet the needs of those seeking justice, right to a fair trial and protection of individual rights. In such a legal conventional framework, every member state has to be the guardian of efficiency, that means good timing, effectiveness, access and quality to justice, efficacy, quantity of justice dealt by ordinary jurisdiction of its judicial system. Member states have made considerable efforts to adjust to new circumstances within a short time and to make the best use of existing resources to ensure the functioning of their courts. Therefore, it is also outlined that they should maintain the momentum and draw the lessons from this experience. Mostly, the crisis cannot be used to excuse deficiencies in judicial systems, and even less to reduce standards or breach legal guarantees. Such a health crisis may be repeated, it's almost sure. Therefore, the judicial systems have to be prepared, notably when it comes to effective solutions to ensure the continuity of court work and access to justice while respecting individual rights. In this context, the CEPEJ reminds the member states of the following important principles enshrined in an official statement made in June the 10th, CEPEJ Declaration. Principle 1 is human rights and rule of law. Trust in justice must continue even at time of crisis. The principles of Article 5 of the European Convention on Human Rights, right to liberty and security, and Article 6, which concern the right to a fair trial, have to be protected at all times and become especially important during the crisis. The continuous functioning of the judiciary and of the services provided by justice professionals needs to be ensured based on European standards. A crisis requires immediate and urgent response. However, any kind of reaction to the crisis must be strictly based on the principles of the rule of law and must respect and protect human rights. Emergency measures must respect the principles of legality, first of all, legal certainty and proportionality, and need to be constantly re-evaluated. So judicial authorities, as well as representatives of justice professionals, should, where appropriate, be consulted on the emergency regulations. Any measures introduced must have a fixed end date, and judicial review must be possible in due time. This is what happened more or less in the Italian judicial system. So, principle 2 is about access to justice. During a pandemic, locking down courts might be necessary to protect the health and safety of justice professionals and court users. It should be done in a careful and proportionate manner, as it results in an important limitation of access to justice, which is a fundamental principle of the rule of law. The public service of justice must be maintained as much as possible, including providing access to justice by alternative means, such as online services, or strengthening access to information through court websites and other means of communication, like phone, email, etc. Greater consultation and coordination, also locally, with all justice professionals, including lawyers, enforcement agents, mediators, and social services, will help to ensure a good level of access to justice. Access to justice must be ensured for all users, but at the time of health crisis, special attention must be devoted to vulnerable groups who are even more at risk of suffering from the situation. Thus, judicial systems should give a priority to cases which concern these groups, such as cases of domestic violence, in particular against women and children, involving elderly people or persons with disabilities, or concerning serious economic situation. In Italy, we added also another clause, which is the urgent case that is given by the lawyers and adjudicated by the judge as an urgent case. Vulnerabilities arising from the crisis should also be taken into account. So the third principle is the safety of persons. When you open the tribunals, you have to guarantee all that. Ensuring the health and safety of all the justice professionals, as well as of the users in courts, must be a priority during and after the health crisis. Not only during, but also after, we have to think about. Safety measures need to be put in place to respect the necessary physical distancing within court premises. All measures need to be prepared in consultation and explained clearly to all concerned, regularly evaluated and adapted to the new circumstances. They may require additional investments in the court infrastructure. Teleworking should be open to justice professionals. They should be provided with the necessary secure IT equipment. Particularly, attention needs to be paid to their well-being during teleworking, and in particular to the fact that these are exceptional working conditions which may require appropriate support. So the fourth principle is about monitoring case flow, quality, and performance of the justice system, allowing for a better and flexible allocation of resources and as close to local reality as possible during and after the crisis is instrumental in ensuring the emergency functioning of the courts and preventing any aggravation of existing difficulties within judicial systems. The well-functioning case management systems and mechanisms of statistical data collection concerning the functioning of the courts is especially relevant during a health crisis. Court presidents, mostly, judges and authorities responsible for court management should continue to monitor and manage cases according to their responsibilities, even remotely. This includes a triage of cases and possible prioritization of the redistribution of cases based on objective and fair criteria and ensuring quality justice. Given the number of cases that could not be processed and adjournments of hearings, human resources and budgetary support should help courts to put in place a plan to absorb delays. So, the fifth principle is about cyber justice, which is very interesting nowadays. The recourse to information technology offers the opportunity for the public service of justice to continue functioning during the health crisis. Ensuring cybersecurity and the protection of personal data must be a priority. However, its rapid emergence and excessive use may equally bring negative consequences. IT solutions such as online services, remote hearings, and video conferences, as well as the development of digital justice, must always respect fundamental rights and principle of a fair trial. To reduce the risks inherent in the deployment of IT, their use and the accessibility for all the users should have a clear legal basis. Special attention should be paid to the most vulnerable groups in this respect, like prisoners, I think. The impact of the use of these technologies on justice delivery should therefore be evaluated regularly and remedial measures taken when necessary. For example, in Italy, the legal system decided to give the chance to choose whether to go through scripts or presence or hearings in presence or in video conferencing by the parties. If there is an objection by one party, the video conference is prohibited, and so the judge can choose to do it by script or either in presence with safety rules. Principle 6 is a training. We need also training of administrative staff, training of judge, every person who deals with the justice system. Training is also fundamental for the effective management of the health crisis in the future. Judicial training should adapt to emerging needs, including the use of IT. New curricula should be developed to support justice professionals during and after a health crisis. The closure of courts and the lockdown measures put in place can allow justice professionals to devote more time to training from home in a safe and secure environment. Training institutions should develop, such as university, should develop the use of e-learning platforms. Specific training on the teleworking should be provided for justice professionals. Specific training on the new types of cases arising from the COVID-19 pandemic should also be provided for justice professionals. Justice professionals should be consulted by competent institutions, including via online surveys on such specific training needs. This is something that is going on now in Italy, especially in the Tribunal of Milan, which was really affected by the coronavirus pandemic. Principle 7 is a forward-looking justice. This is very important. According COVID-19 pandemic has also been an occasion to introduce emergency innovative practices. A transformation strategies for judiciary should be developed to capitalize on the benefits of newly implemented solutions. some aspects of a traditional court functioning should be reconsidered: relations with media, level of use of new technologies, increased recourse to alternative dispute resolution, which would be a key also to solve the problem of quantity of justice during that time, and in particular to mediation. Transforming the judiciary for the future should be approached in a positive manner and always with respect to fundamental rights guaranteed in the European Convention environment. It would also be appropriate to maintain the necessary dialogue between all actors in the justice system and to take advantage of the new relations created between judges, prosecutors, court staff, lawyers, enforcement agents, notaries, mediators, and experts at the time of the health crisis. I think that the pandemic will spur all these actors of the judicial system to work better together. So, I want to just outline some final remarks. The pandemic interval is too long for being deemed in terms of a general suspension of constitutional rights and right to a fair trial. This has been the first stage of the coronavirus pandemic, but now we have to think it as a normal way to go on. So access to quality justice might be enhanced with alternative means, supportive administrative staff, and sufficient funds. The most important political gesture to be done by justice operators, lawyers, judges, and administrative apparatus is to govern it and leverage of its initial curbs through constitutional principles, as I told before. Thank you very much. Now I leave an open window for answers, for questions and answers. And I thank you very, very much. Thank you. If there are some questions, I might prefer to view them from the chat line so I can understand better if there are problems with connections. I hope you had a good connection, by the way.
Dear students, if you have any connections, if you have any questions, please put it in the chat box.
In the chat box, I prefer because I can understand better.
Yes, ma'am. So you might be able to only share the share your questions in the chat box with me. That's okay. I will copy paste it and ensure ma'am gets it. So please do comment in the chat box if you have any questions.
There is Rohit, Roy School of Law. I see.
Yes,
but I don't see the question. I don't see the question.
Rohit,
no, that was...
Civil procedure codes is examination of evidence, witness, or documentary in open court. Yes, now I see it. Thank you. How would this element be affected during COVID times with modified cyber trial in civil case particularly? Yes, it is a very interesting question that is circulating in all the European legal systems. The solution that has been given by the Italian government is to avoid to have, during this time so far, witness depositions and to have only documentary allegation and to go through scripts instead of video conferences, unless there are parts of the proceedings where it is necessary just to hear lawyers who want to express better their briefs and to talk to the judge. Why? Because now, so far, the softwares that we have received from our government, and our government has chose the Teams software, don't work so well for video conferences, especially for civil proceedings. While if I have to talk about criminal proceedings, so far, also the Italian criminal procedure also have set a system of video conferences directly in the hearing room, where it is possible to have an overall view of all the procedures. So it's possible to celebrate a ritual criminal trial, while this is not possible during civil procedures. So the chance is to choose between scripts and oral arguments expressed by the lawyers. When you have to hear witnesses, is the judge order the hearing in presence of the parties with all the safety rules set. Do you have another question?
Yes, ma'am. We have another question. I'll be pasting it in the chat box.
Yes, this element. Now I have to see, huh? Be patient, I will arrive. How do we ensure there is no fraud during examination of witness and evidence, since body language and reactions are important for the judge and the lawyer to observe and gauge? This is a very interesting remark, and I agree with it. And it's the cause by which the Italian legal system didn't take this way so far, because so far we don't have hardwares sufficient in order to guarantee genuinity of witness evidence. I agree with it also because if you want to agree the genuinity of witness evidence, you have to protect the environment from interference. And so I think in the next future, we have to think about which kind of other tools we can manage in order to guarantee, neutral environment around the witness. I think the challenge of video conferencing will be to do it with the presence of lawyers, for sure, and witness and lawyers, and cross-examination, to allow also cross-examination in order to make it possible to listen also witnesses who live very far away from the judicial post, and so from the tribunals, in order not to stop the justice system just for one witness. I add that also in European country there is a law, a regulation, who allow also to judges to hear witnesses of other states concerning different trials dealt by other states. So you can delegate another judge in order to hear witness in another state in the place that they live, which is a guarantee of a fair trial as well. Now, do you have also other questions?
Yes, posted it in the chat.
How do you choose a crowd? This is okay. How does the judge decide the compensation in the cases, considering the fact that the pandemic has made people jobless? Compensation for legal expenses, I cannot understand. There is a question concerning the compensation for legal expenses during the pandemic that has made people jobless. There is an equity rule in the European legal system by which also the judge can consider if there are equity motivation in order to compensate this illegal expenses and not to condemn the loser party to in order not to condemn the loser party to pay the legal expenses of the other adversary party. I think that the judge judgment will be the best way in order to adjudicate also these kind of cases, because the main rule is that the losing party has to pay expenses also for the winner. But in this case, the judge can assess in a different way. Another part of this is to consider that also the people who cannot afford to access to justice can have also aid by the government in order to apply for legal aid, especially in a European country. It is also another rule governed by a regulation which guarantees the fair trial as well. So free access is always some very hard part of the justice system to be guaranteed also through these tools who guarantee effective access to justice. I hope to have responded to the question in a satisfying way. So there is another, wait, I have to go through. How do we ensure there is no fraud during examination? Oh, no, this is the last slide, session. Thank you. Thank you. You too. Wouldn't the change into video conferencing of court trials encourage perpetrators and certain witnesses to voluntarily absent themselves with excuse of technology concerns? And if to be punished for this, how can it be done? The right to have a witness is something that is protected in all legal systems. For instance, in Italian law, it's not the witness are obliged to go under examination, and if they do not do, it's a criminal fault. And so I think that will be important, first of all, to build up a system of cyber justice very secure in terms of protection of data protection as well. And you know, also all the civil hearings, especially in European systems, are not public because they deal with private interests. So there must be also a guarantee under these terms for witnesses that have to feel free about their own genuine and free deposition without running the risk of being spread all over. So the technical equipment should be I think, governed by the central government and the Ministry of Justice in order to guarantee all these kind of data protections. And we cannot, for sure, give this part, leave this part to private corporation and enterprises, just give this service for the justice system. Would the change into video conferencing of court trials encourage perpetrators? Okay, this is done. Sorry, but it's difficult to go through all the questions. Wouldn't the change into video conferencing encourage? Oh no, this is the same. This pandemic has exposed the world to what certain experts believe is the new way of life. One of these new ways is the impact of the legal system, especially filing of petitions online, accepting and submitting evidence, etc. Are you of the view that this is something that will change our legal systems forever? I don't think that this will change our legal system. It will improve, I think, the legal system toward more transparency, because, you know, if you advance all your briefs, all your arguments with legal briefs, sometimes, especially if you put online and you construct, you build up also a digital justice system, especially for civil proceedings, it will be everything, the order of the trial will be preserved, maybe better than the usual order. I'm sure that in common law systems like yours will be some problems because you are adjusted to hearing, which is with oral arguments and also with a cross-examination, and so the trial is like a competition, a real competition dealt by lawyers and governed by the judge. But I think that the result, there will be some adjustments. I cannot have an idea how it will work, but some adjustments will make the process much more rational than sentimental and passionate, as the common law systems have. Much more similar to civil law systems, I would say. And that is very interesting to observe in advance. I don't think that a legal system will be lost forever. It will change in a different way in order to guarantee to people to deal it in a safe and fair way. How the prisoners' rights can be protected during these times and what measures are taken to protect the spread of virus in crowded prisons. This is a problem that had to face the Italian government first. And there has been also a rupture in a prison in South Italy. All the prisoners went away, fled away because of the threat of the virus, and so the government decided to go toward private forms, domicile forms of imprisonment. And the experience showed that this worked also because there was an entire lockdown during around the country, not only a lockdown concerning the parts of Italy concerned, but it was decided just to an entire lockdown of 60 million people of Italy. And so also this way to govern also the prisoners' policy has been successful during this time. It is also an aim of the government to enlarge this kind of alternative forms in order to expiate penalties and with control, strict control in their own domiciles. Another question is, Maham, as you mentioned about cyber justice, wait, I have to go through, scroll down. The cyber justice, I would like to know as to how we can achieve cyber justice during these times in the situation where there are problems of data localization arising with the use, wait, so there are problems with data localization arising with the use of tracking apps used by various governments in different states internationally, as these apps do carry certain risk of citizens' data being breached due to the hacking and various other reasons. Where do we look for recourse to such problems, whether on local level or at an international level? Thank you. Yes, there has been in Europe a great debate. You know that the European system has a very strong database protection regulation, and some apps have been introduced and proposed, and there is one app that has been suggested, not imposed by our government. The result of it is that only a few million people, I think no more than 5 million in Italy, uses this application. Although there have been some suggestion that this application guarantees anonymous detection, and is just used in order to detect people who have been in touch with coronavirus hit persons. My opinion is that it's not working so well in European because of this distrust in this kind of social control. European people don't like it, but as a result, now we are doing a lot of testing in order to detect the infected ones in a certain context of areas. So far, the situation in Italy after the end of the lockdown, which ended May the 12th, is still good because all people take care of themselves. All people follow the rules in order to guarantee social distance. And especially because I don't know if you know it, but Italians have also a very high percentage of elder people, and so the young people want to preserve their elder ones, that have been really affected, especially in the north side, in the elder residences, and all. So the bad experience we had as the first people hit by the Chinese virus led the people to follow the rules of social distancing, which I think are working even better than in technological detection of infections. And so what I suggest is just not to slow down with those measures that are really proving to work really well, although we are leading a normal life so far. Madam, do you think conducting video conferencing is based on the presumption that everyone has internet connection, which in fact is not true in India, where we don't have internet at all times? So isn't that violation of fundamental rights under Article 32 of the Indian Constitution, which ensures that no citizen can be denied access to justice, as that is a fundamental right? I think it is a very good question, because access to justice through IT technology means that you have to have a technological environment around you. Usually, lawyers have it because lawyers are at the upper level of the society, and so it's an instrument, especially in Italy. Every civil proceeding is digitalized now, so lawyers are continuously connected, have to be connected with law courts. What about people? People wouldn't be a problem, because access to this kind of systems should be given to by lawyers at first, and also guaranteed by the justice system. So we can create, for example, posts, IT posts at the police station. Why not? In order to allow people to connect to the courts if they wish to have information or to talk to administrative staff or to judges. I don't know if it is possible in your legal system. In Italy, is not considered rated a proper way to address to the courts, but I know that in some legal systems they do either. The courts have extended the period of limitation for filing appeals, suits, etc. during the pandemic. Do you not think that it will lead to a considerable delay in the cases, and somewhere justice will be compromised? Would you suggest an alternative somehow prevent the delay? I talked to you before about this problem, which is a problem of all the systems. Appeals will be delayed for sure. The problem is to create a task force, internal task force, in order to deal with the backlog that there will be, and to especially and now to work very hard in order to keep up with the track of trials and the quantity of trials we have to deal with. Maybe also the technology, IT technology, will allow in order to make it all in order, and to prioritize also certain kind of civil suits instead of others. There will be a mondial problem, a worldwide problem about this. And now we'll see how the legal system will react. Okay, now see. Maham, it was a great session indeed. In your article titled Independence, Efficiency and Quality of Justice, Comparative Perspectives, January, you had a highlight the issue of long-pending court hearings that often affect the quality of the court. How would you, shifting to a cyber trial, bring a positive retrospective change to such issue? I think that first of all, as it happened in the Italian system, we have to build up a digital trial for civil proceedings. I told you before. And in Italy, it has been introduced in 2010 as a mandatory trial. and in the appellate level in 2014. And it works because the case management by the judge is very important in order to create an ordered schedule of a trial and to create a schedule also according to relevant cases and important cases or urgent cases. So transparency is really guaranteed by the digital era. What we should do is just to work in very hard way in order to guarantee also the allocation, neutral allocation of cases within the judges, to guarantee independence of judges as well, and to switch to this kind of IT technological support in order to also to have a speedy trials, different speedy trials, depending upon the quality and the urgency of the trial. So I think the IT will be really a strong support for the next future. If we have it, we have to build up it in a very serious way, governed by public government and not by private people as well. I don't hear well.
Can
Hello?
I be heard? Hello?
Now I hear. Yes, now I hear better.
Yes.
Can you hear
Go
me
ahead.
at all? Right. So I think, ma'am, if you maybe stop the question answers here, unless you'd like to answer one or two questions, really up to you. But or we can stop the question answer session at this point, because I feel like you've been very patiently and very exhaustively answering every question. So would you like to end it here? Would you like? There's one more question left. If you'd like to answer that, it's up to you, ma'am.
Okay. I see another last question. We may go through all. Ma'am, is it viable for a data depository system similar to dematerialized shared depositories to be used for authentication of documents and of identity, combined with the blockchain and face recognition, of course? I don't know if I understand well the question. The problem which is concerned here is about to protect secrecy and in the meantime, the same time to guarantee authentication of documents and identity. I tell you, in our European system, especially in Italy, as we had a longer backlog, a serious backlog, we worked for it. And now all the authentication of the documents have to be done by the lawyers who advocate the case. The lawyers can be substituted by another colleague for doing that, and they are responsible for that. So that is a good way in order to guarantee authentication and identity of the documents, which is very important to guarantee during a civil procedure.
Right. I think we'll end the question and answer session there. Thank you so much. Can you hear me at all, ma'am?
Yes.
Right. Like I said, thank you so much again for so patiently and so exhaustively answering everyone's questions. May I now invite our head of department, Dr. Sapna, to put forth the vote of thanks for such a wonderful session that you have given to us. So, Dr. Sapna, can we have you, please?
Thank you, Dr. Rohit.
Hello.
Madam Francesca, thank you so much for being here. And it was lovely to hear your entire program. Now I'm just in for the formal vote of thanks. Am I audible? Ma'am, are you able to hear me?
A little bit interrupted now. If you want to ask me a question, it's better if you go through the chat line because I can hear better.
Yes, ma'am. Now, because I'm not going to be asking a question, rather what I will do is that I will be rendering the vote of thanks. So I'm very keen that, you should hear our warm words. So am I audible now?
Yes, yes, sure, clearly now.
Yes. This is the Distinguished Guest Speaker Program by the School of Law, Christ deemed to be University, as a part of the International Relations and Foreign Policy Committee. At the outset, let me take a moment to pay my gratitude and extend my thanks to our respected director, Father Benny Thomas, for his support throughout, and Madam Francesca Fiecconi, your talk on civil procedure code during the COVID-19 pandemic and the constitutional principles was impeccable in its flow and content. And like my colleague, Dr. Rohit was just mentioning, you so patiently answered the questions of all our students and in the most comprehensive and detailed way. Thank you so much, and we look forward to more such visits to the university and probably sometime a physical visit to the university too. We will be so happy to have you on our campus and meet all our lovely students. Thank you so much. And I'm joined by my colleagues and students in extending our gratitude to you for sparing this time. Thank you again. To my senior colleague, Dr. Jayadevan S. Nair, the Dean, School of Law, Christ deemed to be University, who has been coordinating this event right from the inception, and he was the first one who coordinated and brought this onto the floor. Dr. Jayadevan S. Nair, many thanks to you, sir. Dr. Rohit Roy, for your meticulous groundwork throughout in organizing this event. Thank you. Dr. Vidya Jacob, for your support to this program. I thank you too. Mr. Ashwin, who has been a panacea for all our tech issues, and you have been our tech savior time and again. A huge thanks to you too. Department coordinators, Dr. Fincy, Dr. Shampa, and the LLM coordinator, Dr. Sunita Abhay-Jain. Thank you so much for your support throughout and always. All my dear colleagues and friends and dear students, for your involvement and engagement as always. Thank you very much. Madam, thank you once again. And let me just call in Dr. Rohit Roy just for a second in case he just wants to say something. Dr. Rohit, over to you.
Right, can you hear me?
Yes.
Right, and thank you, Dr. Sapna, for that. And again, once again, I thank you, Justice Francesca Fiecconi, for addressing us on this such a pertinent issue. I end this session with the hope that the School of Law, Christ University, has found in this lasting relationship with you, with many more interactions to come. Justice Francesca Fiecconi, grazie mille. Right, and I thank everyone here for being such a wonderful audience. Goodbye and thank you again. Thank you so much.
Namaste.
Namaste.
Thank you.
Thank you.
See
Goodbye.
you next time. So I understand that we will have another nice appointment for sure.
Excellent. Thank you.
And I
Thank you,
thank
madam.
you also, especially you also, for having given us this great opportunity to create a real legal international community.